Hi, welcome to the WG Legacy Podcast, the #1 estate planning podcast in Malaysia. My name is Ian, and today I would like to list down 5 common mistakes that young parents make in will writing. And so let's begin our podcast today with a case study on John. So John is 40 years old, and he is married to Stella, his 35-year-old wife, and they have Solomon, their 5-year-old son. They are residing in John's property, and John has some cash savings, EPF, and has bought some life insurance policies. At present, John has nominated Stella to be the beneficiary of his EPF and life insurance policies, and he intends to bequeath his property and cash savings to Stella, his wife. And so the question is, should John write a will to bequeath his property and cash to Stella? Well, the answer is yes, John could do so. And here, let's assume that John passes on after he has written his will, and at that time, Solomon is still a minor. Here is what will happen to John's estates. First, Stella will inherit John's EPF and the sum assured from his life insurance policies. But when it comes to his property and cash, they will be frozen upon John's passing and will be stuck in the estate administration process. To speed things up, Stella will first need to locate and have access to John's will document, which leads us to mistake number 1, which is the failure to make the will document accessible. So the questions are as followed. First, is Stella aware of the existence of John's will? Second, can Stella locate John's will document? And finally, could Stella have access to John's will document if it is placed in a safe deposit box? So here's the thing. If Stella is not aware of the existence of the will document, or she could not locate or have access to the will document, then it is almost as good as John passing away without writing a will. Now with that, let's move on to mistake number 2, which is the failure to appoint an executor in a will document. First, let us talk about who an executor is and his role in the will document. So an executor is responsible to execute the will document on behalf of the deceased. He is the person who will apply for the grant of probate from the High Court. Then subsequently, upon receiving the grant of probate, he will collect all the deceased estates and proceed to settling all of the deceased outstanding debts and taxes. And finally, the executor will distribute all of the remaining estates to the intended beneficiaries. But if there's no executor, Stella will have to apply for a letter of administration with will annexed to expedite the will. The process to execute John's will this way will be much lengthier as compared to John having appointed an executor in his will before passing on. And now with that covered, let's move on to mistake number 3, which is the failure to consider simultaneous death for both husband and wife. So let's say John writes a will and bequeaths all that he has to Stella, his beloved wife. And subsequently, John and Stella pass away together due to an accident. So the question is, will Solomon, their son, be the only beneficiary of John's estates? Well, the answer depends. If John's will could not be located and John's parents are alive, his estates will be administered as if John has not written a will. And as such, 1/3 of John's estates will be distributed to John's surviving parents, and 2/3 of John's estates will belong to Solomon. But if both of John's parents had passed on, Solomon would be the full beneficiary of John's estates. However, remember this, Solomon is still a minor, and so this leads us to mistake number 4, which is the failure to appoint a testamentary guardian for your children. So in Solomon's case, the questions are, number 1, who shall administer Solomon's share of John's estates? Number 2, is it John's parents or any other Solomon's relatives? And number 3, will Solomon receive John's estates after John's parents had passed on in the future? So as you can see, without appointing a guardian, it adds to the uncertainty as to who shall care for Solomon and manage John's estates on behalf of Solomon. And finally, we have mistake number 5, which is the failure to discuss with your spouse when writing a will. Okay, so here is a question. What if Stella passes on shortly after she inherited John's estates? And also, what if Stella fails to write a will before passing on? Well, this is what will happen. Stella's estates including her inheritance from John's estates, will be distributed in a ratio as follows. 1/3 will be distributed to Stella's parents, and the other 2/3 will belong to Solomon. As such, if you are John today, the question to ask is this: would you be okay with leaving behind a portion of your estates to your wife's parents? All right, so we have covered the 5 common mistakes that young parents make in will writing. As such, let me list down 5 key considerations that you can make before writing a will, and they are as follows. Number 1, where should I store my will and who will have access to it? Number 2, who should I appoint as the executor of my will? Number 3, do I need to have additional clauses to prepare the event when my spouse and I pass away together? Number 4, who should I appoint to be the guardian of my children? And finally, number 5, discuss with my spouse to have a much comprehensive estate plan for my family. And with that, I will conclude episode number 4. I hope that you have gained more knowledge and insights about writing a will document. Thank you so much for listening, and for more information, please check out our website, which is wglegacy.com, and you may download a special 30-page strategic report on estate planning at wglegacy.com/report. And once again, it is wglegacy.com/report. And with that, see you next time. Goodbye.